Legal expert Norman Eisen has reportedly discovered three very important clues that could suggest the Supreme Court's decision regarding Donald Trump's immunity from federal criminal prosecution in the case involving election meddling that was filed against him on January 6, 2021. The report was published in Salon on Saturday, March 2, 2024. Trump's attempt to postpone the criminal case has gained a temporary reprieve with the Supreme Court's decision to examine the immunity claim trial may be delayed until late summer or fall or maybe after Election Day. It was originally slated to start in March. The question posed by the court, which has never been answered before, concerns whether and to what degree a former president is shielded from criminal prosecution for alleged official activities committed while they were in office. The question posed was clearly heavily negotiated. He said Eisen claims that this issue indicates the justice's skepticism regarding the notion that a president carry out official tasks such as political assassinations and avoid consequences. Eisen highlights three hints in the posed query. In order to simplify the case against Trump, the court first accepted the Circuit Court narrowing principle, which states that it will only consider cases involving past precedents. Second, the court as to the scope of protection, implying that immunity might not be granted in the event that an act is largely political rather than official. Lastly, the word allegedly implies that the judges can decide the case without holding an evidentiary hearing by relying only on court documents. Bennett J. Mann, a legal expert, thinks the court need to frame this issue as narrowly as possible. Adopting a comprehensive strategy would necessitate providing compelling justifications for cases with horrifying consequences like impunity for ordering kidnappings or assassinations. That ruling in this case may establish precedents for future presidents, as well as for Trump. According to Trump and his legal team, his efforts to reverse the results of the 2020 election were within the scope of his job as president, and holding him criminally charged would restrict future president's capacity to make decisions that serve the interests of the general public. Lower courts, on the other hand, have rejected Trump's claim of immunity in this particular case, holding that former presidents are subject to prosecution for whatever crimes they committed while in office. Trump cites the Nixon v. Fitzgerald 1982 decision, which addressed presidential immunity in a Nixon-related civil case. Special counsel Jack Smith contends, however, that this decision applied to a civil action rather than a criminal one. Though G-Man thinks it unlikely that the Supreme Court will reverse its decision in this case, he argues that the court could send the case back to a lower court or allow a jury to determine whether the events on January 6 constituted official acts. Eisen feels that granting a former president total immunity from criminal prosecution may completely change the American legal system, and that the Supreme Court should shoot English auto-generated